Hey, you don't need to touch the mountain.
All right. And
It's already done. You yell out for
what is your name?
Sean Harding.
Good morning, Your Honor.
Good
Ryan
morning.
Davis for Mr. Harding. We have two motions pending today. One is a motion to reduce bond in which the state does have one TBI agent that is here. That will be a brief motion.
He didn't say done, but he's got these people.
Hold up when Brad Shelton walks into court. It's not business. As usual, this guy isn't your average investigator. He's been the undercover player in some of Tennessee's wildest criminal takedowns. If he's testifying, you better believe the state is playing hardball.
At the jail until such time as I call on you, please. All right.
And I've also
I'm sorry, repeat that.
This, I filed a motion to reduce bond on Mr. Harding's behalf. The state has one witness, a TBI agent that is here. I think that'll be a relatively brief hearing on the motion to reduce bond. And then I've also filed a motion to withdraw as counsel, which I think would need to be heard second. And so I'm happy to assist Mr. Harding with the motion to reduce bond whenever the court's ready to have that heard.
Well, if you think it's going to be a short motion, we'll go ahead. Is the state ready to take up this motion for bond reduction? Well, since he's here and in custody, I'd like to go ahead and deal with it if we can.
That'd be fine, Your Honor.
We'll give you space at the table. Just shove all that stuff that the public defender has on that table out of your way.
You catch that the defense attorney is filing to withdraw from the case. An open court, that's not just a red flag, that's a full-blown legal siren. When even your lawyer wants out, things are rarely headed in a good direction.
All right, Mr. Davis, I understand you want to argue the motion for a reduction of bond before your motion of withdrawal, correct?
Mr. Harding has been in custody for a couple of years now. This is one of the conspiracy cases, and despite that, a motion to reduce his bond has never been filed. That being said, he has made the best of his time while in custody. Attached to my motion, he's completed several courses, and Career Academy course in Enduring Skills, another course called the Master Plan, The Only Person You Cheat Is You, and then also an electrical course, and so some job readiness, and he's made good use of his time there. He also has been accepted, most importantly, Exhibit B to our motion, has been accepted into the Cross-Style Center for a year-long residential treatment and recovery program. The acceptance letter was dated March 7th, so this we filed this motion as soon as, and set it as soon as possible once he was accepted into that program. Based on other cases that have been heard today, it appears that his plea settlement deadline is going to be September 22nd with a trial date of late January. And Your Honor, this is a much better use of the taxpayer resources of this county for Mr. Harding to receive not quite a year, but even if he were to be convicted at trial, several months of rehabilitation and treatment in a residential facility that he's required to remain on campus, and certainly the court could put appropriate conditions on that release, but he needs the bond to be set at a significantly more reasonable amount in order for his friends and family to be able to make that bond for him. So I believe he's demonstrated the best conduct he can while in custody, as well as acceptance into a program. He's not asking just to roam free in the community. He's asking to get treatment, and I think that's a better use of resources, and that would be our argument.
Okay, here's the twist. Harling's been accepted into a year-long residential rehab program. Could this be a redemption arc in the making, or is it a well-timed chess move to sway the court Let me know in the comments, would you give this guy a second chance?
I intend to call him as a witness unless the court sees fit.
All right, your argument is, your case will be based solely on your argument, and he has a charge of driving a revoked license, second offense, unlawful drug paraphernalia uses and activities in 2023 CR 10, and then, if I understand correctly, according to the docket, he then has a case of, that's the conspiracy case,
Yeah,
300 grams or more, and then he also has another separate indictment of 2023 CR 19, charging him with possession of methamphetamine with intent to sell, unlawful drug paraphernalia, and resisting arrest. All right?
yes, Your Honor. I've got four case numbers.
Right.
It's
And there is
possible I
another
missed one.
case of possession of methamphetamine with intent to sell 0.5 grams or more, possession of heroin for resale, possession of a weapon by a convicted felon, possession of firearm during a dangerous felony.
Yes, Your Honor. All 23 cases, I've got numbers 10, 19, 21, and 62.
And what is the aggregate total bond that he has?
$235,000.
All right. I've heard your argument. We'll allow the state to respond. All right, call your first witness.
I do.
Can you please state your name for the record?
My name is Sean Atkins,
And where are you employed?
Tennessee Bureau of Investigation.
And did you participate in a multi-agency investigation involving a wiretap?
Yes, I did.
And who was that wiretap on?
It was on the Dantes Good drug trafficking organization.
Okay. And during that time,
Boom, the total bond hits $235,000. That's not a bond. That a wall judges don't throw out numbers like this lightly means they see danger, flight risk, or both. Clip 5. This is where it gets serious. We're talking wiretaps, multi-agency operations, and an alleged player in a full-blown drug trafficking organization. The moment Hardings voice it, that wire, he wasn't just a suspect, he became a target.
are you familiar with whether or not Mr. Harding was arrested prior to the conspiracy?
Yes, ma'am.
And do you know what he was found with during that time period?
The first I learned of it was in, I believe, September of 2022. He was arrested for possession of methamphetamine, heroin, and a weapon.
Okay. And are you familiar with how much methamphetamine he had?
Yeah, it was estimated that it was over 100 grams of methamphetamine. I don't know what the exact total was when it came back from the lab.
Okay. And you said that was on September 26th of 2022?
Yes.
Okay. Were you able to, was Mr. Harding on the wire at all in the Dantes Good organization?
Yes, he came up in the wire around December of 2022 and through January 3rd of 2023 multiple times.
Okay, and can you tell us what it means by that he was on the wire? Explain what his participation was.
All right, during the wire, we were listening to the telephone of Dantes Good, the primary target of this drug trafficking organization. We identified a number coming from Sean Harding, where he contacted Dantes Good to arrange drug purchases.
And would he travel to pick up those items?
Yes, ma'am. He traveled to Davidson County.
And was he seen on surveillance during that time period?
Yes, ma'am.
Okay. And looking at the wire purchases, are you aware of how many purchases of drugs and the different types of drugs during that? I think you said from September to January.
Yeah, between December 2nd and January 3rd, we intercepted approximately 10 phone calls or conversations between Mr. Harding and Dantes Good, during which drug transactions were arranged. Those transactions included methamphetamine and heroin, or fentanyl at this point. The total of those transactions that were arranged or talked about resulted in, combined was 29 ounces of methamphetamine and 10.5 grams of heroin fentanyl. And when I said they were arranged, the conversations were set up for a price, an amount, sometimes not a price, sometimes not an amount. Sometimes it was understood between two individuals what they wanted and what the price would be. But it was where the conversation further supported that they did meet to exchange those drugs. And on the January 3rd occasion, we actually had the surveillance out where we saw Sean Harding in a vehicle meet with the Dantes Good organization and pick up methamphetamine.
And was he later found that same day with methamphetamine?
Yes, ma'am. Later that same day, he was traffic stopped on Highway 46 near Interstate 40 here in Dixon County, and he had approximately 4 ounces of methamphetamine on his person.
And I would presume that the quantity of drugs that Mr. Harding was purchasing, in your experience, is not for personal use.
Those quantities are usually for resale, not for personal use.
And are you aware of whether or not Mr. Harding made any admissions in this case?
Yes, in January, or in the September incident, he stated that you got me, and I believe he also spoke to agents at that time in September.
Okay. And did he admit to selling the narcotics during the conversations?
Yes, ma'am.
Thank you, Judge. I don't have any further questions.
Davis, you may cross-examine.
Good morning, Agent. My name is Ryan Davis. I represent Mr. Harding. When Mr. Harding was apprehended, he was also found to have needles on him and signs that he'd also been using, correct?
Yes, I believe in the September incident, there were needles found in the car.
Okay. And it's not uncommon for someone to sell to support their habit in
No.
your line of investigation.
No, sir, it's common.
And you believe that that was probably the case for Mr. Harding?
Usually with most people that we investigate, they're also users as well as distributors to fund their habit.
Okay. Nothing further, Your Honor.
Need to redirect? Thank you. You may sit down.
Thanks, sir.
Any rebuttal?
Despite the state's evidence, the purpose of bond, and I understand one of the factors in the motion to reduce, or factors in setting bond and reducing it, is likelihood of conviction. But Mr. Harding is still presumed innocent. Even though he's wearing orange and he's been in custody for a couple of years, his presumption of innocence carries with him all the way until trial. And there are multiple factors for the court to consider, including his time in the community of almost 30 years. He was gainfully employed in ways other than selling, the allegations of selling drugs.
He's not a resident of Dixon County for 30 years. He's a Davidson County resident.
Well,
correct?
resident of Tennessee, Your Honor, and nearby, and with longstanding ties in the community. And the purpose of bond primarily should be to secure a defendant's attendance back at court. And I believe it can do so here. And again, he's made best use of his time, and the community is better served by Mr. Harding, who, again, if the state is able to prove these allegations, I think the proof at trial will show he was trying to support his own habit. So allowing him to attend and complete a residential treatment job readiness program with a high bar of accountability is a better use of the taxpayer resources, and we believe a significant reduction in his bond is appropriate.
Your Honor, I would just argue that there has been no testimony showing Mr. Harding's ties to the community or his previous employment. The only testimony I would argue that's been shown, other than obviously the certificates that were provided, is the fact that Mr. Harding was on multiple occasions found with and on the wire purchasing large amounts of methamphetamine as well as a fentanyl, heroin fentanyl. These obviously are serious charges, Judge. I believe there's strong evidence that would show that we could convict Mr. Harding of these charges. In fact, the fact that he was admitted that he was buying and selling the drugs, these are Class A felony charges, at least in regards to the conspiracy case. He's looking at 15 to 25 years or more, depending on his range of punishment, Judge. And I would ask that he not be released due to the fact that of all the different charges, Judge. And I believe it also to bring to the attention that on 9/26/22, I believe he was found with a gun. I think that because of the seriousness of these charges and because there is a danger to the public due to the fentanyl and the gun, I would ask that the court keep his bond the same.
And considering the request for a bond reduction, I'm required to look at the factors that are set forth in 4011-115 of the Tennessee Code. Those factors are as follows. The defendant's length of residence in the community. This court is of the opinion that his 30 years of being a resident of Davidson County don't qualify him to be a resident of Dixon County community, and that's we are not an adjacent community. We are sometimes considered to be a bedroom community of Davidson County, but I don't think his 30 years of living in Davidson County qualifies